Okay, whoops. All right, sorry, forgot my light. Anyway, so I have three articles for you today. Two are from the Supreme Court decisions from today, and one was just brought to my attention thanks to Instagram. Now, this article, and I'm going to start with it. This article is from Detroit. I mean, the news source is from Detroit. Niger military junta introduces new penal code criminalizing homosexuality with 5 to 10 years in prison. Now, what is interesting about this is who all this all affects, because it's not just gays and it's not just trans, which those are usually the two biggies. All right. Niger's military junta announced a new penal code that criminalizes homosexuality, an advisor to the justice minister said Friday. Now, this was written June 12th. So, the West African nation is the latest to criminalize homosexuality, following similar measures earlier this year in Senegal. The new penal code punishes anyone who commits or attempts to commit an immodest or unnatural act or practices lesbian, gay, bisexual, transgender, queer, intersex, asexual acts with between 5 to 10 years in prison and a fine, according to the text of the new penal code. Okay. Now, it's awesome that they went after the entire, what do the rights call us? Alphabet mafia. But, quick question. What are, now, gay, bisexual, lesbian, transgender, all those, we know what they mean by acts. Now, we obviously will disagree on why, whether they should be penalized, because they shouldn't, because you're just being a normal human being. But at least that is something that people know what you mean by that. Same thing with being trans. The whole concept of transitioning is what they're talking about. Again, we all know what they're talking about. What are queer acts? What are intersex acts? I mean, they can't, they even more so than being trans or being gay, they even less can help that they were born intersex, because that's a thing that happens. Some people are born with sex organs of both males and females. What exactly is an intersex act? And somehow even more confusing is, if it's even possible, is what the hell is an asexual act? Now, granted, there are multiple flavors of asexuality. Mine in particular is aromantic asexual. So, okay. Now, when you think of an act, you think of someone actively doing something. Now, in the case of, say, me, what act am I doing? Because I am staring down the barrel of my double nickel birthday and I'm unmarried, no kids, that ship has totally sailed many, many years ago. Seriously, how? That's not an act. I mean, how is that an act? Technically, and granted, this is one of the annoying things people say to asexuals, especially if you're religious. Technically, I am acting no different than a nun in that regard. So, again, how is this an act? Romantic asexuals. What asexual act are they doing that's any different than, especially if they're heteroromantic? What act are they doing that makes them different than straight heterosexuals? Because the only difference is that they're heteroromantic and they may or may not be engaging in sex. So again, what is asexual about them? I mean, I guess unless their partner is trying to pressure them into sex and they won't give in, but which would basically be saying that we're basically legalizing rape, which is probably even more ick than all the others. Because at least with the others, no one's going to force you to have sex. But what about aromantic asexuals? They're highly likely not to be in a relationship with a straight person. They're going to go for queer platonic relationships. So even if the person is of the opposite sex, they are most likely not going to be sexual. They're either going to be also asexual, or they're just going to be totally cool with the fact that you're not going to want to have sex. Because, let's face it, if they're aromantic, you're not exactly going to be able to go on a traditional date with them and romance them, because bleh, totally not going to work. So, okay, so you're already going to be attracted to someone who isn't going to do that, who isn't freaking Don Juan. So again, how would that be? How would you even know to prosecute that? Again, unless you happen to make the mistake of dating someone who is pressuring you to have sex. But again, most of those people are also going to want to romance you to begin with, and you're going to be like, no thanks. Now, asexuality is not a well-known orientation. So most asexuals are probably, especially of a certain age, are going to not use the term. They're just going to be like, I'm not interested. And it doesn't have to be, I'm not interested in anyone. It's just, I'm not interested in you, which once upon a time, that was totally okay. It was okay to, yes, rejection hurts, but it was totally cool to be rejected. Most of the time, well, I shouldn't say most of the time, but it was generally accepted that you handle rejection well. You don't attack the person. It's becoming more and more like, yeah, you rejected me, I'm coming after you. But, so, I just don't understand. I mean, granted, what is a queer act? What is an intersex act? Especially intersex. How do you perform an intersex act? You are literally born with with sex organs from two different sexes. You are not actively doing shit. That's even worse in that regard, because what the fuck is an intersex act? Not that I know what a queer act is, but I guess if you act abnormal to a gender role, is my guess. But intersex, literally, what the fuck does that mean? Asexual, what does that mean? Because, again, all asexuals have to do, especially asexuals. I'm surprised that Niger even knows what asexuality is. Or they just went down the acronym and just assumed that because it's all part of the LGBT community, that must mean that it's some sort of perversion. So it's entirely possible that they just don't know what words mean. So they just because they just know of this acronym, they just put the whole thing into this as if this is, it says immodest or unnatural acts. What immodest acts are any of these people doing? Are you talking about pride parades? I don't know exactly what flavor of Christian Niger is. Or even if they are Christian, they might... No, I'm pretty sure they're Christian. But... Carnival, Mardi Gras, that ring a bell? So that's number one. Now, unnatural acts. Okay. Now, obviously, they think unless you are straight, everything is unnatural. We know that. We totally understand that. And if you are anything but cisgendered, obviously unnatural, because these people can't accept that they aren't the gold standard for human. But queer, okay, what's unnatural about that? Do you even know what that word means? Intersex. Well, technically it is unnatural, but in the sense that it's not common, it's unusual. However, it is probably considered a birth defect. However, that's not an act. That is literally how you were born. So again, it might be unnatural, but in the sense that it's not common, it might be considered a birth defect. But I know once upon a time it was. But how is that an act? It's literally not. Even at least all the others, you have to show that you are any of the other letters, well, except for the possible exception, again, of asexuality, which is the lack of sexual attraction to people. Which, again, is not the same as behavior, because you could be heteroromantic and be in a relationship and have sex with your partner if your partner is sexual. Now, and it's possible that said asexual enjoys sex. So, again, how do you distinguish the fact that they're asexual from heterosexual in that regard? Obviously, the difference is they're not sexually attracted to their partner. However, they are willing to have sex with said partner. Not the same thing. But, okay, but that person's asexual. So how the hell are you going to police that? Okay. Now that I went off a little bit on a tangent. Well, not really, but I I did go off on a rant. This same penalty is applicable to persons who officiated the marriage. So this is about marriage. Again, I have questions. To the witnesses of the alleged spouses, as well as to persons who have given their consent for the celebration of the marriage, and to the organizers, the new penal code said. Okay, this article is missing so much. Okay. Now, so the people who attend or are actively a part of same-sex marriage are also subject to this 5 to 10 year penalty. Okay, so we went from unnatural acts to marriage. Okay, that was quite the whiplash. All right. Hamidou Julan, an advisor to the Justice Minister, confirmed to the Associated Press on Friday that the law took effect on Thursday. Previously, homosexuality wasn't illegal in Niger, but has been heavily stigmatized. Laws prohibiting homosexuality are common across Africa. More than 30 of the 54 countries criminalize same-sex sexual acts. Okay. Sucks, but yeah, we knew that. Niger has joined countries like Senegal, Kenya, Sierra Leone, and Tanzania, where penalties can include 10 or more years of imprisonment. In Somalia, Uganda, and Mauritania, the offense can carry the death penalty. Okay, so that is the end of that article, and I am just still, I have so many questions when it comes to intersex and asexuality. Like I said, they probably just, jotted down what each letter stood for, completely not understanding what any of those letters mean. I mean, yeah, they understand gay, they understand lesbian, they understand bisexual, they understand transgender, but they obviously don't know what queer means. They sure as hell don't know what intersex means. Nor do they know what asexuality means. Because those three, in the context of this penal code, make zero fucking sense. Anyway, let's move on to the Supreme Court. And the shit pile that they just dropped on us. Okay, let's start with this first article from the SCOTUS blog. Court sides with government in dispute over rights of green card holders accused of committing a crime. Now, based on this title, you think, okay, the government wants to kick out green card holders who committed a crime. I wish it were that simple. It's not. Let's get into it. The Supreme Court on Tuesday in Blanche versus Law cleared the way for immigration officers to more freely deny lawful permanent residents, also known as green card holders, admission into the United States. By a vote of 6-3, the court, in an opinion from Justice Clarence Thomas, held that federal immigration law does not require border officers to have clear and convincing evidence that green card holders have committed a disqualifying crime before preventing them from re-entering the country for an indefinite stay. So just think about this for a second. Basically, you're a green card holder, and let's face it, this is code for if you're not white. So, because I've mentioned before that I was born when my parents were just green card holders. First thing they did when they got the green card, it was around the time of the World Cup, I think. They hopped over. Now this is in the 70s when you could actually do this. They just hopped over the border. They just walked over the border to Nogales, so they could buy tequila, just do whatever they do. I don't know if the World Cup was on at the time or if it was just to buy tequila, and then they hopped back over. No, they just got their green cards. Based on this policy, they could have been detained. However, of course they would never have been because they're white. So, obviously, they wouldn't have been detained. So, this is basically punishing people, even if they're green card holders, for daring to go visit family in Mexico or somewhere in South or Central America and trying to come back simply because they're not white. So, because why else would these border officials detain any green card holder without any evidence of a crime being committed if they weren't just screaming that they want brown people detained? I mean, you've got your green card, so it's not like, it's not like anything nefarious is happening. Anyway, Justice Ketanji Brown Jackson dissented in an opinion joined by Justices Sonia Sotomayor and Elena Kagan. Jackson asserted that the court's opinion undermines the benefits and security that come with having a green card. Exactly. And wrote that she is worried that the court has handed the government a massive blank check to put lawful permanent residents in immigration limbo. And that is totally the point. She's being nice and letting the conservative justices know that, oh, by the way, this is a thing that might happen. Bullshit, they wanted that. Why would Clarence Thomas want non-white people to be discriminated against? Not a clue. But I guess because he's married to a white woman, he thinks that contrary to his melanin, he's white. I honestly do not understand why Clarence Thomas would do this. The others, well, they're just run-of-the-mill racists. But yeah, she's making it sound like she's just, filling them in on a deep, dark secret. It's like, no, that's the intention. The case stemmed from a June 2012 encounter between immigration officials and Muk Choi Lau, a Chinese citizen and lawful permanent resident of the United States who, 1 month earlier, had been charged under New Jersey law for allegedly selling nearly $300,000 worth of counterfeit shorts. Under the Immigration Nationality Act, lawful permanent residents such as Lau are typically admitted into the country. That is allowed to enter and stay indefinitely after a short trip abroad. They are only to be treated as seeking an admission under a few exceptions, such as when they have committed a crime involving moral turpitude. That is, a dishonest or immoral act, such as fraud or theft. Because of this exception, immigration officers paroled Lau rather than admitting him. He could enter the U.S. to face prosecution, but the officers deferred consideration of his eligibility for admission. Okay, now, so in this case, he did indeed commit a crime. However, so obviously the Supreme Court, in their infinite wisdom, answered questions that weren't even up for debate, because that's how they roll. Now, but still this is problematic. Because think about it. U.S. citizens who commit crimes, they can come back into the U.S. and nobody says shit. But green card holders are a bridge too far. Why is it that the people behind this act like U.S. citizens never commit crimes? They commit crimes. They can commit crimes overseas, come back into the country. They can commit crimes in the U.S. and leave the country and are admitted back in. What are we doing here? Oddly, it's refreshing that this person is Chinese. Still shitty. 1 year later, Lau pleaded guilty to trademark counterfeiting, and he was convicted and sentenced to 2 years probation. The Department of Homeland Security then began removal proceedings on the ground that Lau's conviction made him ineligible for admission under the INA. Lau fought his removal, contending that he had been improperly classified by immigration officers in June 2012 and should have been admitted, which would have forced the government to treat him as a lawful permanent resident and seek to remove him on the ground that he was deportable. My God. Okay, so yes. You want to deport him for committing a crime? Okay, fine. But they're preventing green card holders from being properly admitted because they're green card holders. And let's face it, if he was white, this would not be happening. Like I said, this is only against non-white people. We know this. It's not rocket science. Except for MAGA. MAGA and even maybe a lot of run-of-the-mill Republicans might insist that this has nothing to do with racism because, God forbid, racism actually still exists. An immigration judge and the Board of Immigration Appeals rejected that argument, but the U.S. Court of Appeals for the Second Circuit agreed with Lau. Immigration officers, the Second Circuit held, must have clear and convincing evidence that a disqualifying crime has been committed to decline to admit a lawfully permanent resident into the country, and the immigration officers considered Lau's reentry did not. Okay, so that's where that question comes from. Cool. So they didn't make up that question. The Second Circuit provided it for them. All right. That at least makes some nominal sense. On Tuesday, the Supreme Court vacated the Second Circuit's decision, holding that border officers do not need to meet the clear and convincing evidence standard to treat a lawful permanent resident who has been charged with a crime of moral turpitude as a candidate for admission. Nothing in the INA imposes that burden, Thomas wrote in the 9-page majority opinion. It came instead from an opposite Board of Immigration Appeals precedent. Okay. Still, that's bad. I mean, you don't need clear and convincing evidence. That's basically giving them, like Ketanji Brown Jackson said, a blank check to prevent non-white people from coming in. She didn't phrase it that way, but let's face it. She knew just as much as I do that that's what's happening. Because if there was a white person who committed a crime, they probably would have no problem admitting him. That BIA precedent, Thomas continued, addressed the evidence the government must have during a removal hearing, not during an encounter at the border. He rejected Lau's assertion that the government expressly conceded that this evidence standard applied at No, that this evidence standard applied at the border, explaining that the government had made that concession only with regard to removal proceedings. The court was also unconvinced, Thomas explained, by Lau's claim that a lawful permanent resident cannot be found to have committed a crime involving moral turpitude until he is convicted of such a crime. A straightforward reading of the text contradicts Lau's interpretation, Thomas wrote, because a government may regard a lawful permanent resident as seeking admission as soon as he committed a crime involving moral turpitude, even if, as in Lau's case, the conviction occurred later. So basically, for green card holders, the idea of innocent until proven guilty does not exist. You get charged with a crime, obviously you committed such crime, so you can no longer be admitted into the US. You can only be brought in for immigration, for a trial, for the trial of said crime, and then kicked out. I mean, if they did the crime, okay, fine, I can see that. But that would mean that they were convicted. If they weren't convicted, how the holy hell do you know that someone didn't just completely make shit up and this person is completely innocent? You don't. So, yay. Not only can the immigration enforcement prevent people at the border from entering the US if they don't like you, it's also because, let's face it, they're not going to just see, oh, was this person charged with a crime on their profile? No, they're going to just, claim that they looked shady and go with that. I can totally see that happening. Even if these people have no criminal charges on their record, not even a parking ticket, I can still see that happening. And just the idea of, like I said, just the idea of treating a green card holder like this when they are only charged with a crime and not convicted. Again, innocent until proven guilty. What happened to that? Oh yeah, I guess this court thinks that it's only for white people. Just like, Trump tried to make it that due process was only for white people. Anyway, we declined to read into the INA an additional clear and convincing evidence burden on border officers entrusted with making quick judgments on the spot when that burden is nowhere in statute or even board precedent, Thomas concluded. Quick judgment on the spot. So I'm just looking at you and decide you look shady? Because I would think that they would want to, if they want to, your passport does not tell you that this person has been charged with a crime. So it's no longer a quick judgment. Is this the equivalent of Kavanaugh stops? Where you're quickly let go if you're a U.S. citizen, but in reality, no. Is this did Thomas think, oh, Brett Kavanaugh got a cool thing named after him. Let me try. What the hell? Anyway. In her 17-page dissent, Jackson argued that the text, structure, and context of the INA should have led the court to a different conclusion. Under the plain terms of the statute, she wrote, the government has no discretion to deny a lawful permanent resident admission into the country when it does not yet have evidence to justify that decision. The removal hearing, which can come months or even years after the LPR is is demoted to seeking an admission status and paroled in, is too late for the government to carry its burden, according to Jackson. Jackson emphasized what was at stake for lawful permanent residents, asserting that a demotion to the status of seeking an admission is not costless because it makes it possible for them to be immediately detained or paroled. The downsides of detention are obvious, Jackson continued, and parole can lead to a serious negative repercussions, including a loss of one's permanent green card and the ability to work. It is a fundamental maxim in our country that all are innocent until proven guilty. Where have I heard that before? Jackson wrote, and yet Lau was divested of his already admitted status, deemed an applicant for admission, and paroled solely on the basis of an indictment. Congress could not have meant for the guarantees afforded to lawful permanent residents to be so cavalierly swept aside, Jackson concluded. Exactly. This is not... But, like I said, if this person was white, I'm sure that they would have accepted his argument. But since this is a Chinese person, obviously we don't want non-whites in this country. Because I still don't understand Clarence Thomas. I mean, the fact that the others are racist, but Clarence Thomas, does he understand that if he wasn't MAGA, that people would be calling him the N-word? Actually, they might still be doing that. That they would treat him like pond scum. I mean, I just do not understand people who are part of an ideology completely against their, not just self-interest, but their ability to survive, their ability to live. It is just insane. All right. So that is the end of that article. So let's move on to their second, and I can't say this is a worse decision, but yeah, if you wanted to pretend that the Supreme Court, when they are screaming about religious liberty, are talking about all religions and not just Christianity, this is proof that no, that is not what they care about. The only religious liberty they consider to be relevant is Christianity. This is from Reason magazine. Supreme Court limits the ability to sue prison guards for religious liberty violations. All right. Another day, another unfortunate decision by the U.S. Supreme Court that shields rights-violating government agents from facing accountability. Or, as the girls of strict scrutiny call it, bad decisions. No, I am not referring to a new case about qualified immunity. The judge made doctrine that made it hard to sue a bad cop for constitutional violation. And no, I am also not referring to the line of cases involved in so-called Bivens immunity, which have made it even harder to sue an abusive federal officer for constitutional violation. I am referring here instead to the ability to sue a prison guard for religious liberty violation under the terms of the Religious Land Use and Institutionalized Persons Act. Among other things, that federal law says that if a state prison system accepts federal funding, it must generally refrain from imposing a substantial burden on the religious exercise of its inmates as a condition of receiving the funds. Which makes sense because, hello, the First Amendment still exists. Yet, in a 6-3 decision issued today, no points for guessing which 6. The U.S. Supreme Court held that prison guards employed by the Louisiana Department of Corrections, which accepts federal funds and is therefore bound by the RLUIPA, may not be sued for damages by an inmate whose religious liberty was seemingly violated. Seemingly? They were violated. The inmate in question, Damon Landor, was a Rastafarian with long dreadlocks that he had been growing out for years as part of his religious practice. Was a Rastafarian? The man isn't dead. At least I don't think he is. When LDC guards sought to shave his head, Landor produced a paper copy of a decision by the U.S. Court of Appeals for the Fifth Circuit, which said that the prisoner's ban on dreadlocks was illegal as applied to Rastafarians under the RLUIPA. But the guards just tossed Landor's copy of the ruling in the trash and forcibly shaved his head anyway, leading to this lawsuit. I mean, this is just proof, like I said, that in the mind of this Supreme Court, the religious liberty only pertains to Christians. The fact that he was black probably didn't help, but no, the main thing is that he was something other than Christian. Writing for the majority, Justice Neil Gorsuch, joined by Chief Justice John Roberts and Justices Clarence Thomas, Samuel Alito, Brett Kavanaugh, and Amy Coney Barrett, shielded the guards entirely from Landor's lawsuit. Why? According to Gorsuch, if Congress wants to place such strings on the receipt of federal funds, the recipients have to agree on the strings. I'm sorry, what? Imagine that. We want to have a rule that you can't murder. We want to have a law that you can't murder people. And the person who murdered someone's like, I don't agree to those rules. How is this? Laws exist for a reason. It's the fucking First Amendment. I do not understand. Even if this act didn't exist, it's the First Amendment. Oh my God. And while the Louisiana Department of Corrections does not question that it has agreed to answer certain RLUIPA suits as a condition of accepting federal funds, Gorsuch wrote, the individual prison guards being sued in this case did not enter into such agreement. Are you fucking kidding me? So not only does the institution have to agree to agree to the strings that allow you to enter into this program, but the individual people working there have to agree. It's called a job application. If you are applying for a job and you don't agree to follow the rules of that institution, then don't take the damn job. What is with this idea that if you happen to be white and Christian, and yes, I'm assuming that these prison guards are white, why is it that that people like them are supposed to be treated as above the law, and that they think that they can get away with literal murder because they happen to be Christian. And being Christian is the most awesome thing you can be. And so, because of that, they're beyond reproach. Ugh. All right. Now, where was I? And because they never agreed to answer suits like this one, Gorsuch maintained, Mr. Landor's case cannot proceed against them any more than a breach of contract action might proceed against a defendant who never formed a contract. You formed a contract by agreeing to work there. Okay. There is a sovereign citizens movement. This writing by Gorsuch basically is gold for them, because they can simply say, we did not enter into a contract with the United States, so we don't have to follow any of their fucking laws. I mean, he basically managed to argue against people following laws. I mean, yes, I was born in this country, but that doesn't mean I agree to follow any of these laws, because I didn't choose to get born here. So, that's how stupid this sounds. I could stop following certain laws because I'm like, well, I didn't make a contract with the U.S. It's not my fault I'm a U.S. citizen. I was born here. Are you kidding me? How is it that a lawyer has managed to rule against people following laws? It is unbelievable. Okay. All right, now where was I? In other words, while Landor may sue the prison system, he may not sue the guards. Well, as far as I'm concerned, if he can, he should do just that. It's like, okay. Of course, I don't know why he didn't sue the prison system, because he could technically get more out of that than the individual guards. But, yeah, as far as I'm concerned, it's like, okay, fine. I will refile against the prison system. Now, and let's see what other brilliant ideas Gorsuch will come up with, or the rest of the conservative majority will come up with, as a reason why that lawsuit shouldn't go ahead. I must say that I find Gorsuch's argument here to be more than a little strained. That is so nicely put. So understated. These prison guards are agents of the state acting under the color of state law. Yet the guards now get a free pass from being sued, despite the fact that the state agency they work for, the LDC, is admittedly bound by the terms of the RLUIPA, which the guards acting in their official capacity as guards seem to have clearly violated when they forcibly shaved Landor's head, thus imposing an unlawful substantial burden on his religious exercise as a Rastafarian. It seems to me that a guard ought to follow the same laws and requirements that bind the prison system that he or she works for, or else face the same kind of consequences that the system itself would face. But 6 members of the current Supreme Court think otherwise. As a result of their judgment in Landor versus Louisiana Department of Correction, yet another category of government agent now enjoys extra protections from being sued over a likely rights violation. Okay, so that is the end of that article. And yeah, I'm just gobsmacked at this Supreme Court. I understand that they desperately want to, if this guy was Christian, they would be all over this and demanding that the prison guards be fired, probably, and, how horrible they were to this poor Christian. But because he's a Rastafarian, obviously not a problem. Let's just find a way to argue ourselves into people don't have to follow laws. Because again, there is a sovereign citizens movement, and if they have even nominal intelligence, which is questionable, but it's possible, if they have any nominal intelligence, they're going to seize upon this ruling and upon Gorsuch's reasoning and use it as a reason to not follow laws. Because Gorsuch has said, you didn't enter into the contract, you didn't physically sign a contract, then you're not bound by the contract. So the people working for an institution don't have to follow the rules of that institution, because apparently institutions can break laws, but institutions can't break laws, but people can. I'm sorry, does he think that a building was going to shave a Rastafarian's head? What is happening? Is he just saying that only the administrators could be sued? Seriously, who could be sued under this ruling? I can't think of anyone. Possibly the administrators, but they're not the ones who would be shaving a Rastafarian's head. So basically, they gave carte blanche for the sovereign citizens movement to violate whatever laws they want. Actually, they've given carte blanche to literally anybody violating rules, because they can just say, I didn't sign this contract, so why should I follow this rule? Again, same with U.S. citizens. I'm talking about birthright citizens, not those who become naturalized citizens. I'm talking about those who are born citizens. We didn't sign any contract. It's just assumed that we're going to follow the rules, but we didn't have a ceremony saying we would do that. There is literally nothing that we signed or declared or whatever that says that we're going to follow shit. So if we didn't sign a contract, we don't have to follow the rules. I don't think this is what Neil Gorsuch had in mind. And I really, 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 really hope that somebody calls him on this. That the next time somebody gets sent to court for whatever reason, whether it be a sovereign citizen or just a U.S. citizen, someone will take his reasoning and use it as a reason for why he broke such and such a rule. Well, I never signed a contract. Yes, I'm a citizen, but I never signed this contract physically, so I don't have to follow the rules. I really, really hope somebody does that, simply because hopefully it will show the abject stupidity of this ruling. Now, will the Supreme Court understand and accept that it was a stupid-ass reasoning? No, they will come up with some reason why all these other cases are different. But it isn't going to change the fact that it is a stupid-ass ruling. Okay, so with that, I believe I have covered everything I wanted to in this video. And with that, I will see you guys in the next one.